Good morning, everyone, and welcome back to our weekly webinar series. Today, we are having our 86th continuous weekly episode, and we have taken up the topic of looking at all the recent judgments from the Supreme Court of India and the High Courts with respect to SARFAESI. For those who are not aware of SARFAESI, SARFAESI is practically used for enforcement of security by banks, and that part of SARFAESI has really reformed in the recent past. And the various court judgments allow a lot of credibility to the SARFAESI action done by banks and financial institutions. So over to Anil, sir.
Thank you, Ankit. Welcome to our 86th weekly webinar series. I sent a message to my audience in the morning that SARFAESI is much cleaner, effective, and faster as compared to other options available with the secured creditors. Because the SARFAESI is applicable only to the secured creditors. So therefore, this particular webinar and whatever we are trying to deliberate today is applicable to the secured creditors. So how we can say that the SARFAESI is much cleaner, faster, and effective for recovery of dues as a secured creditor. So first of all, let me say that SARFAESI law has primarily 3 chapters, and in 3 chapters, the first chapter deals with the setup and monitoring of asset reconstruction companies. The second chapter deals with the enforcement of security interest, and the third chapter deals with the centralized registration of mortgages and charge created by anyone on the assets of a particular maybe corporate debtor or any other person. But that's say like the central registration is applicable on any entity, irrespective of whether it is a private limited or a proprietorship concern. So now today, when we see there are issues like faced by the secured creditors, and the first such issue is that the whether the dues of statutory authorities towards any kind of tax, state tax, central tax, so any amount which is payable to Consolidated Fund of India or Consolidated Fund of a state or a local authority, that has actually become an issue for the secured creditors. So we all would recall that there is a judgment of Rainbow Papers by Honorable Supreme Court, and that was delivered in June 22. And as per that judgment, the statutory authorities, wherever they have in their law provisions regarding having a lien on the assets of the taxpayer, they would become secured creditor. So as per section 53, the first category, the priority has been given to the secured creditors, and conspicuously the word financial is missing over there. So the first priority is after the CIRP cost and the liquidation cost, the first priority is the payment of secured creditors along with the some payment which is due to the workman in a pari passu manner. So this is the priority given. So when the word financial is missing in the secured creditors, that means even the operational creditors can also become secured. And if the creditor is a secured creditor, irrespective of the fact whether it is a financial creditor or an operational creditor, will enjoy that priority of section 53, subsection 1 and clause B. So this is the first thing which is actually disturbing the distribution pattern in the case of resolution plans and also in the case of liquidation. So then on 17th July 2023, we got a judgment from Honorable Supreme Court in the case of Paschimachal Vidyut Vitran Nigam Limited versus Raman Ispat Private Limited. I've been saying that even Raman Ispat Private Limited was also a case handled by AAA Insolvency through its partner, Mr. Praveen Bansal. And right in 2018, we considered Paschimachal Vidyut Pattern Nigam Limited as a secured operational creditor. So the distribution was also done to that electricity company because of their agreement, which they actually have signed, that in case of any electricity dues pending on the corporate debtor, the electricity distribution company will have a lien on the assets of the company. So we considered them as a secured creditor and were allocated accordingly. So while the distribution was upheld by the Honorable Supreme Court, it was also clarified that while passing the while passing the rainbow paper judgment, the Honorable Bench probably have missed the special clause available in Section 53. And then again, on 31st of October 2023, we again received a judgment from Honorable Supreme Court, which was filed by the various review petitioners against the judgment of Rainbow Paper Mill. So the title of the judgment was Sanjay Kumar Agarwal versus State Tax Officers and various other review petitions. In fact, various other review petitions were decided by one order, and this order, in fact, again, maintained that the rights of a secured creditor would be considered as a priority, irrespective whether the secured creditor is an operational creditor or a financial creditor. Secondly, any lien on the assets of the corporate debtor by any tax law or any other law, that would be considered as a charge. So the question still prevailing in the markets, which are not really answered, whether it is automatic or through a transaction. Like there are many professionals and even the authorities, they are also convinced that if there is a transaction of creating a security interest, which is exactly as per the definition given in Section 331, Section 333, Section 334, and Section 3, subsection 35, these all sections read collectively would actually make it very clear that the security interest as per insolvency and bankruptcy law would be created by way of a transaction. If there is no transaction of creating a security interest, there is no automatic security interest. So Section 3, subsection 31 and subsection 33, 34 and 35 must be seen to understand whether the security interest is automatic or not. Now, this is a present scenario. Unless the amendment is done by the Parliament, the present scenario is that all these tax dues will stand pari passu along with the secured financial creditors, because the secured financial creditors has not been given a separate category. Secured financial creditors has been merged with secured creditor, and operational creditors can also be secured operational creditor. So this is the difficulty number one. Now, how this difficulty is being resolved under the SARFAESI law? Now, this is like the SARFAESI law. In fact, the significant amendments were made in 2016, and some notification came little later, effective January 2020. So because of these notifications and because of these significant amendments in 2016, this issue of rights of the statutory authorities against any tax, cess, etc. has been completely settled. Now, what we want to say now today, that what is primarily written in Section 13, subsection 9 of the SARFAESI law. So this is regarding anyway, I'm not talking about the workman for the timing. I'm talking about the statutory authorities. So we need to see, it's like the Amendment Act of 2016, in fact, introduced a chapter 4A in the SARFAESI Act. In that chapter 4A, that deals with the registration of a particular transaction of creation, modification, or satisfaction of any security interest by secured creditor and other creditors with SARFAESI. SARFAESI is the Central Registry of Mortgages. Section 26E, capital E, of the aforesaid chapter is a non-obstante provision which states that upon registration of a security interest with SARFAESI, the debt due to any secured creditor shall be paid in priority to all other debts, all revenues, taxes, cesses, and other rates payable to central government, state government, or local authority. However, in case the company is already under insolvency and bankruptcy law, then the laws of the IBC will prevail over SARFAESI. That's very clear. Now, when we go through the SARFAESI Act and we try to see what exactly the amendments are, so we actually could see that Section 26B was also a section in Chapter 4A, that is registration by secured creditor and other creditors. Now, in the Section 26B very clearly says that the central government may by notification extend this provision. So, from the date of the notification, now the subsection 4 says every authority or officer of the central government or any state government or local authority entrusted with the functions of recovery of tax or other government dues and for issuing any order for attachment of any property of any person liable to pay the tax or government dues shall file with the central registry such attachment order with particulars of assessee and details of tax or other government dues from such date as may be notified by the central government in such form and the manner as may be prescribed. Now, if any person having any claim against any borrower obtains order for attachment of the property from any court or other authority empowered to issue attachment order, such person may file particulars of such attachment order with the central registry. So that means that the central government, state government, any other person, they are all supposed to be required to submit the particulars of such attachment or such mortgage before the registry. Now, effect of registration is mentioned in section 26, capital C. Now, without prejudice to the provisions contained in any other law for the time being in force, any registration of transactions of creation, modification, or satisfaction of security interest by a secured creditor or other creditor, or filing of attachment order under this chapter shall be deemed to constitute a public notice. From the date and time of filing of the particulars of such transaction with the central registry, where security interest or attachment order upon any property in favor of the secured or any other secured creditor is filed for the purpose of registration, and this chapter, the claim of such secured creditor or other creditor holding attachment order shall have priority over any subsequent security interest created upon such property, and any transfer by way of sale, lease, or assignment or license of property or attachment order subsequent to such registration shall be subject to such claim. Now, what I am trying to say, the first part that I would say that the there is a notification issued by Ministry of Finance, and that notification, as I said, is effective from 24th January 2020. In that notification, all these provisions are notified with effect from 24th of January 2020. Now, with this notification, Section 23 of the SARFAESI Act is also amendment is notified. Now, what this amendment says, the filing of particulars of transaction of securitization, reconstruction, and creation of security interest with the central registry, the timeline of the 30 days has been given. So now it is mandatory for everyone to file the particulars of a transaction of securitization, reconstruction of creation of a security interest. So anyone who files files first will be considered as first charge holder. Anyone who files second, third, or subservient charges, that can be having second, third, or even any subservient charge. So if a secured creditor, if a secured financial creditor has registered its transaction with SARFAESI, which is mandatory for all the financial institutions as per SARFAESI, as defined in SARFAESI, so that actually means that they will have the priority over any other tax dues, any other revenue, any other cess, or any other local authorities dues. So that means the SARFAESI is protecting the financial creditors, secured financial creditors, against any kind of attachment, against any kind of lien, against any kind of court order. So this this problem of rainbow paper is completely resolved in SARFAESI, and with effect from this 24th of January 2020, it is mandatory for all the secured financial creditors to register their transaction of mortgage whenever it might have been created, even if the transaction has been created in 2015 or 2000, even 1920. Again, the registration, whosoever will register first will have the priority over the other charges. So this particular law, it has been held also as enforceable, constitutionally valid by the Supreme Court. So any secured creditor who has a security interest and the security interest is registered with SARFAESI, which is mandatory with effect from 24th of January 2020, is protected against any demand, any attachment from any kind of revenue authority, tax authority, local authority, or any kind of court attachment. So this particular, I just wanted to share with my audience that this is something which is very, very powerful tool to kind of deal with the confusion which has been created by rainbow paper, and then the review petition cited as Sanjay Kumar Agarwal versus State Tax Officer. So Ankit, this is the first thing that I wanted to say. If you would like to say anything on this, which is the main issue presently, the dealing with the secured financial creditors.
I think we have been talking. It's good that we kind of read Raman Ispat. We've been talking about Raman Ispat. We're talking about how the review judgment is only on technicality and not on actual grounds. So it is a very, very crucial requirement to keep using Raman Ispat and that part of that judgment which talks about how Section 53 should be read like this. And because it's a later judgment, it will help many creditors in defending against rainbow paper. And therefore, I think here also in SARFAESI also, in case similar thought process is aligned, that will also help courts take a decision towards, the creditors, secured creditors rather than government dues. So that will certainly help. I also feel that similar clarity is really, really required in provident fund related dues, because there again, that is one major impediment in various cases. And fortunately, PF related dues are settled in SARFAESI, but they are unsettled right now in IBC. So there again, one can kind of work towards that.
So we have a second subject, which is the workman dues, the priority under the IBC and the priority under the SARFAESI. That is the second subject today. So first we have dealt, and in case there is any question on this part, the tax dues or any dues to statutory authorities against revenue tax, against cess, and these dues are completely dealt with. SARFAESI is completely protective because of the registration before SARFAESI, and any registration is having the first charge and the second charge, even if there is an attachment later on. that attachment would not impact the secured financial creditor as defined under the SARFAESI Act. So this subject is completely clear. So the second subject that we are dealing today is the how the different how this workman dues are presently.
So we can take up some questions that are here before
Yes.
moving on to the next topic. So the first question is from Mr. S.J. Goel. He's asking whether provisions of SARFAESI may be used for defining secured creditors under IBC. I think IBC defines secured creditors separately, so there is no possibility of using the definition or provisions of SARFAESI to define secured creditors under IBC. Or do you think that's not the case?
No, I think what he's trying to suggest is, Ankit, like that definition or this definition, because see, the SARFAESI is applicable only to secured financial creditors. So SARFAESI is not applicable to me or you, because the SARFAESI was primarily made for secured financial creditors originally, and later on it was also applicable to specified eligible NBFCs, and it is also applicable to the regional rural banks and the cooperative banks. So the primary difficulty in that country when the SARFAESI came, so it was addressing that issue. However, in amendments, larger amendments in 2016, the SARFAESI Act has become more robust and more powerful, and and then therefore we are trying to say that this particular issue as the rainbow paper has actually been completely resolved in SARFAESI, and there is no impact of rainbow paper on the SARFAESI remedy. Now, coming to the workman, is there any other question?
Yeah, so then there is a question from Mr. Hari Prasad. He says that is there any timeline before which security interest has to be registered with SARFAESI?
So in see on this particular notification dated 20, which is effective from 24th of January 2020, a timeline of 30 days were given. Even today, in case there is anything, anyone who is left should immediately go and file their attachment, file their security interest before SARFAESI. That actually will, in fact, I would advise that if there is any attachment order, immediately that should be informed and that would be submitted and the transaction should be filed before SARFAESI.
Then we have question that whether EOW attachment under MPID Act have priority over SARFAESI.
No, I see this, once the SARFAESI is kind of an act where we have not seen even the PMLA overriding SARFAESI for the time being, because the SARFAESI, the bank can take over the property and sell. And we have not seen so far any order where I have not even seen any order where somebody say that the SARFAESI overrides the attachments of PMLA. But then these kind of orders must be in waiting, but the order has not come. I think there are lot many disputes where the property is already mortgaged and it is SARFAESI registration already been done, and later on it has been attached by the PMLA. It is attached by ED under PMLA. So those judgments have not come, and I believe the ED is attaching all the properties irrespective of whether these are mortgaged or these are registered with SARFAESI. The ED is attaching all, and ED gets the priority. So no such order by Supreme Court or any other court which says that even if the SARFAESI registration under Section 26E is done, then even the PMLA also cannot attach. That is not available.
So Mr. Pradeep is asking that if the PF department wants to register a charge on a property in SARFAESI, can they do that? I don't think they can do that.
But that will be subservient charge. That will be second charge or third charge, whatever.
What they are saying is that the property does not have a SARFAESI charge, and if the PF department attaches that property, can they go to SARFAESI and register that charge? I don't think the PF authorities are members of
PF
SARFAESI.
department can register the charge before SARFAESI because this central registry is applicable. It is not only applicable to the secured creditors as defined under SARFAESI. The central registry is applicable to all.
Understood. So that way, their security then can be known to all banks, and therefore the banks
will become a public notice.
Will become a public notice. Then Mr. Jindal is saying if secured creditors does not relinquish his security in case of liquidation, Section 52 will be applicable. In this case, SARFAESI Act will be applicable about priority of charge, and first amount will be recovered by secured financial creditors. So he's absolutely right,
Absolutely correct.
and this
Absolutely.
is and this is one of the reasons why in many cases we see that there is no resolution plan, there is no asset sale by the liquidator, but this option is selected by those creditors where in cases where where the secured financial creditors are there, but also there are some government dues or PF dues that are held by courts to be in priority over others. Then we have so I think rainbow paper is being talked about again, and there is I think we can continue, and I think I can deal with the remaining questions later.
So now we deal with the second issue, which is regarding the workman dues. Now we have a section which is section 36 in the IBC, and according to section 36, like any dues with regard to the provident fund, superannuation fund, and gratuity fund, that would be kept outside the liquidation estate, and the that would be paid to the like the gratuity, provident fund, and superannuation fund will be paid to them, to the workman. Now, see, the first there was a judgment of Moser Bear Karamchari Union, and that was by Justice Mukhopadhyay. And Justice Mukhopadhyay said in that judgment that irrespective whether the funds are available in these three funds, it is the duty of the liquidator to make payment of provident fund, gratuity, and superannuation fund, and to that extent the amount would not be considered as part of the liquidation estate. Then the Supreme Court, you see that particular matter also went to Supreme Court, and there was another judgment later on passed by Honorable NCLAT, and that was passed by Justice VP Singh, and that judgment was Appala Shiva Kumar versus Savan Godiwala, the liquidator of Lanco Infratech Limited. In that judgment, the Justice VP Singh said that the liquidator is not duty bound to induct funds into these three funds like a gratuity fund, provident fund, and superannuation fund. However, in case there are any funds available in these three funds, this will be kept outside the liquidation estate. Finally, the Supreme Court decided on 7th February 2023. The Supreme Court decided that whatever judgment was passed by Justice Mukhopadhyay in the case of State Bank of India versus Moser Bear Karamchari Union, that judgment, there is nothing to interfere. That judgment it's a very, very small judgment, 2-page judgment of Supreme Court, and that judgment is upheld. Secondly, it is also said that the judgment of again NCLAT in Appala Shiva Kumar versus Savan Godiwala, where it has been held that the liquidator is not supposed to insert funds into these three funds to make payment of eligible workmen, that is quashed. So what happens now is that the liquidator is supposed to pay. The liquidator is supposed to pay the full amount of provident fund, full amount of gratuity, and full amount of superannuation fund. So this is finalized. This was finalized on 7th February 2023. Similarly, these two judgments were in liquidation processes. Then again, there is a judgment of Jet Airways when the resolution plan was approved, and it was held that the gratuity, superannuation fund, and the provident fund of the employees and the workmen, that will be paid, and that will be paid in full. So now, even if it's a resolution plan or it's a liquidation process, the provident fund, gratuity fund, and the superannuation fund has to be paid in full, and I don't think there is anyone who actually is fighting against it, because even I believe the lawmakers are also convinced that these kind of amounts should have been paid. And since the company is changing hands, resolution plan through resolution plan, or the assets are being sold, the gratuity cannot be eaten away, the provident fund cannot be eaten away by just for the benefit of the secured financial creditors or secured creditors. So this is the general view. So we actually can consider that this is a final, and the final view is that the provident fund, gratuity fund, and superannuation fund has to be paid in priority. Now let us see what is the what is the law in the SARFAESI law. In the SARFAESI Act, I could see section 13 subsection 9, and there are 4 provisos to this section, and which deals with the workman dues to be deposited to the liquidator. Workman dues to be deposited to the liquidator in accordance with section 529 capital A of the Companies Act. The lender will retain the proceeds on the sale of assets subject to payment of workman dues as per section 529A of the Companies Act. Now, when I see the corresponding section from 529A to section 325 or 326 of the Companies Act 2013, because 529A is the section which is under the Companies Act 1956. Their corresponding sections in Companies Act 2013 is section 325 and section 326. Now, section 529 capital A deals with the overriding preferential payment, and the provisions are similar to what our section 53 subsection 1 and clause B says. It says that during winding up, workman dues and the debt dues to secured creditors, to the extent such dues rank under clause C of the proviso, that is something like 2 years, and rest shall be paid in priority to all other debts. The debts payable shall be paid in full unless the assets are insufficient. Means the workman dues and debt to the secured creditors, those will be paid in full unless the funds are lesser. And in case the funds are lesser, then the balance amount shall actually stand awaited. Section 326 also says the same amount. There is no difference in these two sections. And the only difference is that in case of liquidation, the liquidator will have the power to claim. The liquidator will have, but that is particularly the official liquidator under the Companies Act. There are no provision which says that the liquidator can do that. So the liquidator also, what I feel that when these assets are being not relinquished by the secured financial creditors, and the liquidator liquidator is having a right that the liquidator would claim the workman's due exactly as per section 529A or section 326 of the Companies Act from the financial creditor, but that would not be as per section 36 subsection 4 of the IBC, but that would be as per section 326 of the Companies Act, because the SARFAESI law provides for that. So even if the liquidator is appointed under IBC, but then in case the security interest is not relinquished in favor of the liquidator under the IBC, then the secured financial creditor will recover this money under SARFAESI Act. Once the money is being recovered under SARFAESI Act, the dues of the workmen and the employees would be claimed by the liquidator. This is my understanding about, although it is not really mentioned, because when this amendments of 2016 came, the IBC was not enacted. So therefore, IBC is not mentioned here, but the spirit of this law also prevails, and the liquidator can claim from the financial creditor. Now, however, in the entire section 13 subsection 9 of the SARFAESI, the secured creditor is only supposed to give the pari passu amount payable to workman dues, and not full amount of gratuity, not full amount of provident fund, and not full amount of superannuation fund. So this difficulty which presently is being felt because the gratuity amount is huge, and which is presently taking away the amount due to secured financial creditors. So therefore, this SARFAESI is actually better remedy to a secured creditors as against IBC with regard to the workman dues. Now, Ankit, this is also covered by me, so I can only say that in case you would like to add, and let us take up the questions regarding this.
So one question from Mr. Hari Prasad is, will leave encashment constitute statutory dues? I don't think leave encashment is a statutory due.
Leave encashment is not talked about in section 36, I think subsection 2, clause B. I think it is not talked about in that. It is only the gratuity fund, provident fund, and superannuation.
Then we say that then we say Rajesh Goelji is asking that in case shortfall in balance of PF gratuity superannuation amount from whether it will be made good before CRP liquidation cost or there will be fall due after CRP liquidation cost. So he's saying whether CRP liquidation cost is a priority over such PF gratuity superannuation dues, or even the liquidation or CRP cost will fall as second to PF gratuity and superannuation dues.
Technically, the way the section has been drafted, it is outside the liquidation estate. When it is outside the liquidation estate, so that actually means that the CIRP cost and the liquidation cost also would not be payable in case there are some funds into this. However, the even if the section is what I understand is the basic intent is to deal with the issue of workmen and employees. The basic intent of the Honorable Supreme Court is to let the workmen not lose their life earnings only to give some benefit to the secured financial creditors. That is the intent. But in the meantime, the intent is also not there that the resolution professional or the liquidator will also not get their salary. So what I feel, even if the law is made in such manner that this liquidation, it will not form of the liquidation estate. So technically, if any asset is not forming part of the liquidation estate, the liquidator will not get any fee on that part. However, the liquidator is, on the other hand, in case you understand, the liquidator is getting remuneration based on the realization and the based on the distribution. So the liquidator is definitely realizing from the assets of the company, they're definitely distributing to the stakeholders, including the distribution to provident fund, superannuation fund, and the gratuity fund. Therefore, although technically the law is made differently or the different law has been used to protect workers, but yes, nobody can deny that the liquidator or the resolution professional will not get their dues. It is only question of liquidator, because as far as the resolution plan is concerned, the resolution plan only will come if there are assets. Otherwise, the company will be liquidated. So it is not a real question for a resolution professional, but for a liquidator, yes, the liquidator should be able to claim his remuneration based on the realization of assets and based on the distribution of assets. And this amount distributed to these workmen would also be considered as distribution. Any other question, Ankit, here?
Then I see a question where he says where there's a question is that what happens to statutory dues or attachments therefrom when the purchaser buys it? Does the buyer have to pay them later? Not really. That's not the idea. The buyer will never be liable to pay them later. It will always be a question with respect to distribution of the proceeds that the buyer has paid to the liquidator or whatever the case is.
Yes, because when the liquidator is transferring the title, liquidator transferring the title is without any liabilities. In case any kind of judgment which says that in this particular case the gratuity has to be paid in full, so then the liquidator will be duty bound to get the return of money under the regulations from the stakeholders, whatever has been distributed, and then distributed to the workmen and employees. But it is not supposed to be recovered from the buyer of the assets in liquidation.
So then, Mr. MSV, not sure what is the full name, but then he says that proof of registration with SARFAESI by implication covers the charges registered with RTO under Vahan. Example, the registration authority under the Motor Vehicle Act by the application of a mandatory notification dated 3rd May 2019 issued by Government of India under the SARFAESI Act. So pursuant to the notification, all charges registered with Vahan stand integrated with SARFAESI. In this regard, a clarification letter dated 4th October 2019 was also issued by RBI, wherein they clearly stated that the financial institutions are liable to register hypothecation charge over vehicles with Vahan only and not SARFAESI, as both stand integrated. Thus, these notifications leave no iota of doubt that a valid hypothecation charge holder registered under the Motor Vehicle Act shall be treated as a secured creditor under IBC. Can we take if financial creditor not registered with ROC but hypothecated with the RTO certificate, can liquidator consider as secured creditor the financial creditor has not created charge with ROC?
I
So
think as far as this is concerned, the charge with regard to the motor vehicles under Motor Vehicle Act, that has actually been considered to be a very, very clear charge on that asset. And even in some cases, the charge has not been created before registrar of companies. That has not been considered as an impediment. That has been considered as acceptable if the charge is registered before the registration authority under the Motor Vehicles Act. Similarly, the registration of a charge before the registration authority under Motor Vehicle Act is considered to be at par with the registration of a transaction of a mortgage with SARFAESI. So it is rightly said that the both these registration authorities under Motor Vehicle Act and under the SARFAESI Act has been integrated. Integrated means in case probably we go and search SARFAESI and it will be found that in case integrated means, I'm not sure technically it has already been done or not, but that is something which was originally planned, that the both will be integrated and both will be considered as one public notice. Yes, Ankit.
technically, what of course I think the only one thought process here that integration is all right. Lawfully integration is there already, but then I
Yes.
think practically also integration should be there. That somebody when they see a company's data on SARFAESI or a vehicle number on SARFAESI, they should see that there's a charge under the Motor Vehicle Act. That is the integration that you are talking about.
Right, right.
So that's about it. Other questions, I think we've already taken care of them, but though they seem to be a little repetitive, so we can skip them. Only one thing that Buffon Motors judgment somebody is asked to discuss, we can always take it up later because that deals with the notice period for auction purchaser for public auction by secured creditor. I believe there was a judgment which was with respect to allowing minimum time which is required to be allowed under an auction for
So in
participants
fact,
to inspect the assets.
there are many judgments which says that the procedure as laid down in the SARFAESI law has to be completely complied with. And if there is any lapse in the procedure, immediately the stay would be granted. And there is no excuse that it is only a very, very small lapse. No, even if there is a lapse of 1 day, it is considered as unlawful. So there are many judgments. Since the law is very harsh, it is taking away somebody else's property. So it has to be completely uh, as per the law and the procedures laid down in the SARFAESI law, including rules. And so this is very clear. So I think the Buffon is exactly like this, that in case the procedure is not followed meticulously, then the SARFAESI also fails. Should we move on to the next subject, Ankit?
Yes, let's do that.
Okay, so now the next subject that we are going to treat is the present matter pending before Honorable Supreme Court regarding the distribution to secured creditors under Section 53(1)(b). Now, it says that the history is that again I'm talking about this Technology Development Board versus Anil Goel, and the corporate debtor in this case was Gujarat Oleo Chem Limited. I was the liquidator, and then I distributed the proceeds after the sale of assets exactly as per the Insolvency Law Committee report, and that report said that the priority of charges and the value of security interest would be respected. And that particular Insolvency Law Committee report was also based on an Honorable Supreme Court judgment given in 2005 in the case of Sidco Lathers versus ICICI Bank. So I distributed it according to the total law laid down by Sidco Lathers versus ICICI Bank in 2005 by Honorable Supreme Court, and also accepted and deliberated by the Insolvency Law Committee report dated 26th of March 2018. So the Technology Development Board filed an application before the Honorable NCLT Ahmedabad, and the beautiful judgment was written by an Ahmedabad NCLT that the liquidator has done rightly, and all this Sidco Leather Insolvency Law Committee was discussed, and also the argument of the appellant, the Technology Development Board, was also discussed, like Section 53 doesn't have any separate category for the second charge holder or third charge holder. Secondly, the value of security interest is missing. And then it was also referred that Section 53 also has a subsection 2, that if there is any arrangement, with subsection 2 of Section 53 says that if there is any arrangement between between creditors having similar priority under Section 53, that would be ignored by the liquidator. So that actually was also argued as that this arrangement of first charge and second charge and third charge or subservient charge is an arrangement between the creditors having same priority under Section 53. So therefore, the priority of charges as agreed between the parties also would be ignored by the liquidator. So based on this argument, the appeal was filed before Honorable NCLT, and Justice Butt gave an assessed judgment titled as Technology Development Board versus Anil Goel, where he said that the arguments of the appellant is right. Section 53 doesn't have a special category for the exclusive charge holder. There is no mention of this value of security. Section 53 subsection 2 doesn't talk about the first charge or second charge or third charge. Rather, the liquidator is supposed to ignore if there is any arrangement. Then that particular appeal, they see again the Technology Development Board versus Anil Goel, that is me, that was challenged before Honorable Supreme Court by a bank which was not even a party to this appeal, and then it was again appealed. So there are about 5 appeals which are now tagged together, and the Supreme Court is presently not hearing that case, and it is pending. So that is regarding the distribution. Now, this particular ambiguity is causing difficulties to secured financial creditors in the following manner. One, that the liquidators, most of the liquidators are distributing pari passu basis based on the total claim of the secured financial creditors. So they are distributing pari passu to the first charge holder and also to the second charge holder and also to the subservient charge holder. So all the secured creditors, even if they're having second charge, third charge, are considered as pari passu, and proportionate amount is being distributed. This is causing a lot of loss to those financial creditors, secured financial creditors, who have a first charge and their value of the security is much higher than the value of security of the others. And also, the liquidators are not giving any priority to the value of security interest. Even if there is an exclusive charge on the asset, the liquidators are not giving because of that judgment of NCLAT in the case of Technology Development Board versus Anil Goel. Now, in this scenario, let us understand the sufferings of the secured financial creditor is that they are getting, some of them are suffering, some of them are gaining. However, those secured financial creditors who have first charge, they are suffering. Those financial creditors who have the value of security interest is higher than the others, they are suffering. And those secured financial creditors who have exclusive charge on some of the assets they are suffering. They are suffering in resolution plan, they are suffering in the liquidation also, because in the resolution plan also it is mentioned that the distribution should be done as per section 53. In section 30 subsection 4 of the IBC, it is mentioned that the committee of creditors may distribute the proceeds or funds available under a resolution plan as per section 53. However, the priority of charge and the value of security is mentioned here, but that is something which is not available in section 53 exactly. Therefore, that resolution plan matters are actually now become a kind of power of voting. So whosoever is having better voting power can negotiate in the resolution process. However, this clarification is missing, whether the priority of charges and the value of security interest. Now coming to the how this part is being handled in the SARFAESI law. Now in SARFAESI law, the definition of secured creditors, the definition of secured creditor is dealt as the because it is very clear. The SARFAESI actually deals with the Companies Act. The definition of security interest is actually as per the distribution would be as per section 529A, that is an overriding preferential payments. In SARFAESI, anyone who actually is having charge on a secured asset, security interest, would be entitled to the distribution. The only lien, a little bit of lien, is that in case the liquidator files a claim to the secured creditor regarding some workman dues, and that also as pari passu, not as having priority over the secured financial creditors, as now we are facing under the insolvency law. So any secured financial creditor who actually takes an action under section 13 subsection 4 of the SARFAESI Act can take over the asset and can sell it, and whatever he will recover, that actually will be retained by him, subject to some payment of workman dues as per section 326 of the Companies Act 2013. So Ankit, this this is also something which is very clearly it's very clear that these three issues that we've discussed today, SARFAESI is a better remedy as compared to insolvency and bankruptcy code. And one fourth issue that I am actually trying to handle today is regarding the tenancy, like the rights of the tenants on the properties of the corporate debtor. That is the last issue that we are going to handle today. However, these three issues, in case there is any question, we can still attend that, and then we'll spend about 5 minutes on the tenancy issues. So these are the four issues I wanted to cover, where the SARFAESI is actually better than the IBC. Yes, Ankit.
I think we can move on. This is perfectly good.
So, let us try to see what kind of protection is given to tenants under SARFAESI law, and what kind of protection is given to tenants under the IBC. In SARFAESI, there has been many judgments from Honorable Supreme Court and High Court. In fact, with effect from 1st September 2016, as probably, see why I am talking so much about SARFAESI is because we also have a lot of experience about SARFAESI. Our company, which is AAA Capital Services Private Limited, that company is the largest resolution agent and enforcement agent under the SARFAESI law in India, and the banks have trusted us with more than 42,000 SARFAESI cases, where we have performed, where we have taken over the assets, we have sold the assets, and we have actually, the banks have recovered based on the efforts that we have made. So we have faced that this is the first suggestion, which is the first consultancy given to the borrower, that you create a tenancy right on your property in case you have to avoid actions under SARFAESI Act. So right from 2002, the consultants have been giving suggestions to the borrowers that you create tenancy rights on your property if you have mortgaged this property to the banks. So there are Supreme Court judgments. Originally, the Supreme Court judgment said that there are three kinds of tenancies. One, the tenancy created before the mortgage creation. Second, the tenancy created after the mortgage. And the third, the tenancy created after the section notice under section 13 subsection 4, subsection 4 has been given to the borrower. So the first is always protected. If the tenancy is created before the mortgage, it is always kind of protected, depending upon the total period of the lease or the tenancy. Second is the tenancy created during the after the mortgage is created. Still, the rights of the tenants are protected, provided the tenant is bona fide. Third is the tenancy created after section 13 subsection 4 notice has been given. In that case, it is said that once the notice under section 13 subsection 4 has been given, the borrower cannot sell, lease, or part away with the possession of the property. So therefore, that tenancy is not valid. However, on 1st of September 2016, it has been held that any kind of tenancy dispute, no DM, no CMM, not CJM would have any power to handle this kind of dispute. If a tenant comes before the DM that I am in the possession of the property, please don't give order to the police to take over the possession. The DM will tell him to go to DRT, because the DRT has been given powers. The Debt Recovery Tribunal has been given the powers to handle all tenancy issues which are with regard to the property, which is a security interest before any secured creditor. So therefore, from 1st of September 2016, the power has been given to Debt Recovery Tribunal. So what I'm trying to say is that these tenancy issues are much better handled under SARFAESI, although all bona fide tenancies are protected. However, in IBC, the resolution professionals and the liquidators are not able to get possession of those properties which are given on rent. The RP or the liquidator will go and approach the adjudicating authority, that means NCLT. So there are various kinds of orders that we have received from various NCLT benches. Some orders are saying that if the lease is valid means it is not expired. The time of the lease is not expired. The liquidator or the RP has no power to take the control and custody. And some have said that if the lease period is expired, then the other person is saying that this matter should go to the local court. The NCLT cannot be cannot be overburdened with all kind of eviction or all kind of tenancy issues. So some has rejected it. Some has said that the tenancy is over, it is expired, the possession has to be given to the liquidator or to the RP. So the clarity is not much, whereas the clarity is much more in SARFAESI. Supreme Court has given like 10 judgments on tenancy that the tenants are protected in case the tenancy is genuine. However, in the case of IBC, the genuineness of the tenancy is not something which has come under any kind of law. It is only the timing of the lease period. If the lease period is expired, then NCLT is helping. Otherwise, NCLT is not helping, saying that it is a normal tenancy issue that should go to a normal court. So these are, Ankit, the 4 issues which I wanted to highlight. And these are really very, very important, because the SARFAESI law is much settled, it is much older. And now there are various orders from Honorable Supreme Court that you can file an application to DM for assisting the bank. You can file an application before the CMM, before CJM. So all the 3 authorities are empowered. And earlier there was a difficulty of overburdened DM, but now those have been delegated to ADMs also. That has also been upheld by Honorable Supreme Court. So the timing for getting an order from DM, CJM or CMM is on an average about 2 months. And see, like in case we see the long back, it used to be something like, depending upon state to state, district to district, it was something like from 2 months, 3 months to 2 years. So the SARFAESI also was very slow, and also the stay was prevalent from DRT. Now I think because of the various Supreme Court orders, the stay also is become very, very rare. And even if there is a stay, those stays are not for a month, more than a month, 2 or 3. So the SARFAESI actually is becoming more robust and more effective. So, Ankit, any question that we can have take up, because we are already up with the time. And today, in fact, I have not used my PPT, and it was coming out of my heart. So I thought that let me even say that these issues under the IBC, in case not resolved, then the secured financial creditors in this country, they would start preferring the SARFAESI route rather than IBC route. Also, I would say that SARFAESI has some limitation for some of those kind of cases where the SARFAESI would not be able to do much, especially where some agricultural land is involved, or where some kind of projects where the mostly the business as a running business is involved. See, because see, like the IBC, in case it starts, in case the overall time period is reduced, I think it will be very, very effective for even uh, handing over, for even taking over a running business and then handing over to somebody else. However, in the case of some kind of businesses which are license based, those it will be very difficult to handle it through SARFAESI, because the license is in the name of the corporate debtor. Similarly, the thermal power plants, the chemical plants, the larger plants, the hydel plants, the wind power plants. These are all various kind of projects which are based on the some of the assets, some of the licenses, some of the agreements. Collectively, it becomes an asset. So wherever some business is collectively as an asset, then only IBC. And if in case there are identifiable assets, those actually would bring better result under SARFAESI. Also, in the SARFAESI law, hypothecation has a different meaning. In case we have to take action uh, for a hypothecation agreement, then first of all the possession has to be taken. Recently, we have taken based on the directions of State Bank of India, we have taken the uh, custody of ornaments and jewelry and diamonds of a borrower. So those, after taking the custody, we can actually sell it under SARFAESI. But in case the stocks are not taken custody, not in possession of the bank, it cannot be sold under SARFAESI. However, it can be passed on to another management under IBC. So this is what, Ankit, in case there are some questions that we can take up.
So, Mr. MP Jindal is asking, IBC is superior to SARFAESI. How can a secured creditor get the CD out of IBC except 12A of the IBC? So, the idea is that the resolution plan gets failed because the resolution plan is not voted on, because the other dues get a preference. Similarly, liquidation, we said that there is a via media that if the resolution plan fails, the liquidator at the time of liquidation, the secured creditor does not relinquish his charge, then SARFAESI can come in picture, and that's what we were talking about. With respect to Mr. Vipul Dubey's question, that he wants us to talk about the dissenting secured creditor for resolution plan as well, that when the dissenting creditor does not even get the liquidation value. So yes, there are a couple of case laws that are available now from the Apex Court, which also talk about this issue, or which have held that okay, it is okay if the person is getting his voting share related money and if he's not getting his liquidation value as a dissenting creditor. Unfortunately, they have passed, the Apex Court has passed such judgments. That's again becoming one more reason for those creditors who are having a dissent in the voting share to not like IBC.
Certainly, I think this Amit Metalinks is one of the judgment which says that the even if the proportionate amount is given to the secured creditor, I think that is better, because see, that is okay. Why they are saying that? Because see, they, while they are holding on to the adjudication of that issue, whether there is a separate category for first charge holder, second charge holder or not. Also, in the distribution, the value of security interest has to be considered or not. If they are sitting on that judgment, on a kind of another judgment which is also using the same section 53 for the purpose of distribution under section 53. So they probably couldn't do much. However, once this particular issue is resolved, which is pending before Honorable Supreme Court, the dissenting creditors will get the liquidation value due to them based on their priority and based on the value of the security interest. So presently, the dissenting creditors are also suffering because of this ambiguity on section 53, subsection 1, clause B.
Then Mr. Harvinder Singh Dhami is asking, what is the default limit under SARFAESI? Default limit is 1 lakh. Anything beyond 1 lakh, they can SARFAESI can be initiated.
Yes. However, for NBFCs, it is 50 lakhs.
And Pradeep ji is asking, can you sum up the suffering of secured creditors in one go now? Plenty of
I
suffering.
think if there are four sufferings. One is the all tax dues, revenue dues, cess dues, anything which is going to Consolidated Fund of India, Consolidated Fund of a state, Consolidated Fund like the local authorities. Second is the workman dues. Full amount of gratuity is supposed to be paid. Full amount of provident fund, full amount of superannuation fund is supposed to be paid. Third is the secured creditors will get pari passu, even if they have the exclusive charge or they are secured or their security value is very high. Fourth is the in case the property is on rent, that issue actually may get little delayed under IBC. I think these are the sufferings which are better handled under SARFAESI rather than under the IBC.
So I think we should wind up. I think it's been a very different episode today. Without any presentation, you have been speaking extempore based on your experience, based on all the summarily you have talked about all the issues and how SARFAESI seems to be better for bankers today. So yes, certainly there is the IBC needs to catch up. So there's no doubt about it.
So thank you very much, my own viewers, and thank you very much for being with us. And we get very happy when the audience is more. Thank you. Thanks a lot.
Thank you, everyone.